As far as it relates to your appearance on screen, if your camera is on, you will need to make sure that you are stationary if at all possible. Again, any type of movement is typically very distracting to viewers and it takes away from our attention. So if you cannot make any unnecessary gestures or movement while on screen, if you have your camera initiated. Anytime you speak to the court, you will need to make sure that your camera is on. If you want to address the court, I will not address anyone that does not have video accessibility. You should not drive, as it is against the law in the state of Georgia to operate a handheld device while driving or to view video while you're driving, unless it is a UPS or GPS video. So please do not drive and break the law on camera. So again, when you're on camera, make sure also that you have clothing on that would be appropriate to be seen in a courtroom setting, and also that you're not doing anything that would be inappropriate to be seen on camera. And again, I know it's a little bit hard for you guys sometimes, but if you can just limit the movement to the minimum, because again, it distracts from the eye of the viewer. And therefore, sometimes I may not hear something that you say because I'm distracted by what's going on with the visual. So just try to be as non-obtrusive and still as possible. Keep yourself muted until it is time for you to speak. I will let you know when I get to your case and get announcements from you, but otherwise your little red microphone should always be showing red on your screen and until it is time for you to speak. And again, whenever it is time for you to speak, you can unmute yourself, make sure your camera is activated at the time that you're speaking to the court, and I will get announcements. So again, have your video going if you're going to address court. Okay, so Ms. Rainey is present. I do, Ms. Smallwood is present as well. Mrs. Rainey, are you willing, Ms. Smallwood, I take the first attorney case?
I wasn't able to hear you. It was a breakup.
Are you willing to the private breakout room to talk to the others, take the attorney case?
Absolutely.
So me and the private to discuss your case, and we'll come back to your momentarily once y'all are done this. Okay, and then Ms. Williams, I will just ask a yes or no question. Were you able to reach a resolution with Ms. Colson?
No, she came in, turned her phone on mute, and got off.
Okay, so let me do this.
Oh, I'm sorry. No, I'm sorry.
Difficulties. Ms. Colson, if you can turn on your camera and also unmute yourself.
Well, she did.
Okay, Ms. Colson, did you intend to speak to Ms. Williams to see if y'all can work something out without having a hearing?
Your Honor, I am not allowed to talk to her because she has a TPO on me.
So my question was, do you have an issue talking to her to see if y'all can resolve the case?
I don't have an issue. I just don't want to be in violation of the TPO order.
Okay, this is court. So you're in court, and this is a court hearing, and y'all are interacting in a court setting, and a judge is saying that you can. So if you would like to speak with her to see if you can prevent her from going forward with a warrant against you, you can. Again, it's in a court setting, but you do not have to if you not want to.
Okay.
But again, I do have 1 or 2 matters I have to take before y'all's case, so it may be an hour or longer. So that's why I encourage people to talk to each other to see if it's something that you can work out, so you don't have to wait while I take care of those matters that I have to take care of before I can get to yours. So I'm going to go ahead and place you back into a breakout room. Just press accept or join, talk and see. And again, you're speaking in a court setting in a court hearing, so it's different. That is the one exception.
Excuse me.
Yes.
I don't want to talk, so you can put us in there, but I have nothing else to say, honestly.
Okay. Well, let me do this just because, again, I'm not going to get to you right away, and I'm not.
That's fine.
3 times. 3 times means that it's just doesn't even make sense for me to repeat myself. Again, I'm telling people to go talk to each other to see if there's anything that can be done short of a criminal hearing to resolve a case. You don't know what someone's going to say or what they're going to offer to do until you talk to them. I typically will make an assumption whenever people don't want to be able to talk to other people and they're difficult with other people, that might be someone that has less of a veracity with me, simply because a person that's difficult with others is probably going to be difficult in general. So again, I encourage people to talk to each other, especially because I'm saying to do it. I'm not asking, I'm saying that I have people go into those rooms to talk to each other to see if they can resolve it, so that we don't have to be here as long. And every time I have to re-explain it, everybody else is here with us an additional 5 to 10 minutes with my explanation. So if it does not work out, you can immediately come back out of the breakout room, but I do wish to see if there's anything we can do to see if we can expedite the matter. So just press accept or join, and then we'll come back to your case. Miss Rainey, I see that you have returned from the breakout room. Just yes or no, were you able to reach a resolution?
No, ma'am.
Okay. Are you ready to go forward with your hearing today?
Yes, ma'am.
Do you have all of your witnesses that you need, or do you have any witnesses that you need?
My witnesses are present.
Okay. And have you already sent via email or brought physically into the courthouse all evidence you want me to look at?
Yes, ma'am.
Okay. Thank you. Mrs. Condry Smallwood, are you ready to go forward with the hearing today?
I am not. I would like to reschedule because my attorney cannot make it.
Have you hired an attorney at this point?
I have one. Yes, I have talked to him. I talked to him earlier today, but he said it was too short of a notice.
Talked to, but have you hired? Have you paid?
Well, I've already retained him. I retained him for something else, and then I called him with this. So I don't know if that's a yes or no.
Okay, so have you paid him for this?
Not particularly for this case, but
okay,
he did say he was trying to make it.
Just listen to the questions that I asked. So at this point, let me make sure everybody's on notice. I don't want anything superfluous. It makes us have to stay here 20 and 30 and 40 minutes longer than we need to. I ask very specific questions because I need very specific answers. So my very specific question is, have you paid him? You have not. My next question is, did he indicate that he would be willing to accept your case if it was reset to another date?
Yes.
Okay. And then the third question would be, are you going to be able to pay him within, let's say, 3 to 4 week period?
Yes.
Okay. So Mrs. Rainey, typically if someone is going to hire an attorney because they face criminal repercussions, such as going to jail and extensive jail time and fine amounts, I typically will allow them to have the ability to have an attorney represent them. And down the point she has towards getting that attorney. And because again, liberty is at risk, I usually will time for a person to get a question to you is going dates. I believe is going to be the first week in December. That first Monday in December will be the first available court date. Because I am resetting it for her, I would give you the which day in December. So we have this the 2nd December, the 4th December. I don't believe we have one the next week. The next one will be in January. So I have December 4th or December 11th, or I can move it to January. Do you have a preference out of those dates?
Everything you just said was like broken up. So I heard bits and pieces of what you were saying. I didn't even get the dates.
December 4 to January if needed.
Okay, so we're moving. She's requesting what? I'm confused. Are we requesting as a hearing or?
Well, I don't need to know the reason. What date?
Well, I'm confused because I thought she said that she was dropping it, and then when I came back on here, you guys requesting a date.
I never said anything about dropping anything.
Hold on 1 second. We do not talk over each other. Madam Clerk, in my absence, can you just mute them? We don't talk over each other. Order that court occurs in. If you're able to resolve it, then we'll reset it for another court date. The court dates are going to be December 4th, December 11th, or January. So the only question that I've asked at this point is going to be, which of those 3 dates would you prefer? A date in January, December 4th, or December 11th?
December 4th.
Okay. Thank you. Mrs. Smallwood, are you able to appear on December 4th at 6 p.m.?
Second. I also have an additional question.
I'm asking right now if you are able to appear on December 4th.
And
at
I'm pulling up my calendar. 1 moment. Yes.
Okay. So what we're going to do is we're going to reset it to December 4th at 6 p.m. You'll need to let your attorney know that that is the reset date. And because you weren't ready this time, this is going to be, it's going to be very rare that I would give a reset date again to the same party. So he does need to be ready to go forward on that date. Madam Clerk, can you do me a favor? Can you put the Zoom ID in the chat feature so I can just put it in the next device? I'm sorry.
That's fine.
And everyone else, give me just one moment. I'm going to switch devices one more time.
Ma, you want me to order you something to eat?
Okay, so again, everyone make sure you're on mute if you're not speaking. Okay, so Madam Clerk, what we will do is reset the previous matter for December 4th at 6 p.m.
May I ask a question, please?
Okay, so one moment, and again, I'm really, I don't understand what's going on today, but everybody just seems to be a little bit out of order at any time. I am going to address you before you need to speak. If you aren't addressed by the court, do not speak out. If you need to speak, use the hand raise emoji or just raise your hand. At this point, I'm not going to let people interrupt because I've had too many interruptions, and we're not going to continue with this because it disrupts the flow of court and it makes it almost impossible for us to get anything done. So again, if you need to speak to the court, you can raise your hand and I will get to you. At this point, I think people should realize that I do try to do things as efficiently as possible. So 9 times out of 10, I'm going to either answer your questions or give you a chance to speak at the appropriate time. So please do not interrupt my court sessions to do that at this point in time so that we can, again, be respectful of everybody's time that is on the call. That being stated, again, Madam Clerk, will go ahead and issue that reset notice. What I will need, Mrs. Smallwood, is your attorney's information. So if you have your attorney's information, I'm going to ask that you put their name and their telephone number, or their email address is even better if you have that in the chat feature, so that we can send your attorney a copy of the information as well. If you don't have that information and you cannot provide us that information, then you will just need to forward the information that we send to you to your attorney. It usually is going to take a little bit of time for us to get those notices in the mail and for them to reach you. So it might take a week or two before the mail gets it to you. So you can just go ahead and let your attorney know orally that it's going to be December 4th at 6 p.m. for both of you on December 4th at 6 p.m. If you have any witnesses that you need, you will need to have those witnesses present so that they can testify. Also, you don't have to have them physically present with you. What you can do is you can have them call into the Zoom ID, and you just provide them the Zoom identification and also the password so that they can join. Just provide the information that we gave you to them so that they can join the Zoom. If you have any physical evidence that you need me to see, paperwork, text messages, email all of that to the address that the clerk just put in the chat feature, because we have to have that information in advance so that we can put it on the screen and show it to the other parties on the screen. So please make sure you have that information to me prior to court beginning. And at this point, I'll start with my plaintiff, Ms. Rainey. Do you have any other questions or concerns? Okay, thank you. Ms. Smallwood, do you have any questions or concerns?
Yes, I wanted to ask, because I don't know the process. This is the 4th TPO that I have put on Ms. Rainey that she is dodging.
So I'm not going to ask any answer questions about the proceeding or about what's going on. Do you have any questions about the reset and what is required of the reset date and time? I don't get into advice about what's going on with the two of your cases against one another.
Okay, so who should I to learn the correct way to make sure all this gets to the right place? Who should I talk to?
So I don't give advice. This is not what a judge does. A judge makes a decision about a case that is currently in front of them. I cannot tell you how to.
Don't worry about it, Judge. Have a great day. Don't worry about it. Don't worry about it. Thank you.
So we'll see Ms. Smallwood whenever she returns. And Mrs. Rainey, you are free to go. Have a good rest of the day, and I will make some copious notes. Thank you. And Mr. Ford, the question that I had for you was the address that you were able to provide for the defendant, Ms. Daniels. How did you get that address for her?
I did not. The detective did it. He did the research, and he said he found it based on she was locked up in Clayton County prior.
Okay. So he had her system from what she put in the system whenever she was arrested in Clayton County on a previous occasion.
To my knowledge, that's correct.
Okay. So give me a second to see how old that arrest would be before I can let you know about the notice or not. So give me just 1 second to research everything, and I'll get back to you in just one moment.
Okay. Thank you.
Thank you. Ms. Colson, you guys have returned. Are you able to get your video camera going? So just
Yes,
remind
ma'am.
me, I don't think y'all did need a hearing or y'all did not need a hearing.
I'm not sure because once I took a screenshot because once she got on,
Hold on one second. Hold on. Don't tell me what happened. I don't want to know what happened in the room. Mrs.
Okay.
Williams, are you here, Ms. Williams? If you are, can you unmute yourself? Okay. And Ms. Williams, were you able to speak with Ms. Colson?
No, ma'am.
Okay. So we'll come back to you guys' case in a moment.
Yes, ma'am.
Okay, so we'll come back out of recess. Mr. Ford, I'll just have you raise your right hand. Oh, never mind. You've already been sworn in. I'm not going to re-swear you in. Mr. Ford, you can unmute yourself.
Hey, go ahead. Can you do it for me, Your Honor? I have no vision.
Okay, yes, I can see you now. And so, Mr. Ford, I'm just going to be brief. I'll just ask you a couple of questions. It looks like per the police report that you submitted that you would get regular Lyft rides from the defendant in this case. Is that correct?
Yes, Your Honor.
And what was the date that she was supposed to come pick you up that she did not?
August 3rd, she was going to take me on a long trip to St. Louis, August 3rd this past year.
Okay. And then when did you pay her for that August 3rd trip?
The end of March, about March 30th, it was in the police report.
Okay. I was just confused about that. You paid her. Why did you pay her so far in advance of the trip?
Well, she took me to a Grady doctor's appointment. On my way home, I explained to her that I was going to St. Louis to see my family as well as a high school reunion, and I was going to fly, and she offered to drive. She said, well, I would love to take you. And I said, well, how much would you charge me for that trip? And she said a total of $500. And she was excited.
Let me ask this. How did you pay her?
I gave her cash when she pulled up to my driveway. When she took me to my Grady, I came in the house and gave her 4 crisp $100 bills. We agreed on $500, but I helped off one $100 bill. I didn't give her the whole 5. I just gave her 4. And after that, Your Honor, she continued to come by and take me shopping to the grocery store for $20, $30. But the day before her birthday, which is July 30th, she called me and asked for the additional $100, and that red flag went up. And then the day before we supposed to went on the trip, she called and asked, was I going to pay for the gas? And I let her know, I already gave you $400. It should be including the whole $500. That morning, she's supposed to show up at my house at 6 a.m. and she never did. I called her at 9 o'clock. She never answered my call. I called my godbrother. He called her from his home phone. Then she called back, said, did someone call? And I was on his cell phone. I said, yes, it's me. You're supposed to came and got me, take me to St. Louis. I've already paid you. And she got real indignant and said I was rude to her and I just woke her up. She was still going to come. She'll be by my house by 12. She never showed up. By 2 o'clock, I called the police.
Okay. All right. So what I will have you do then is you will need to come to the courthouse to go ahead and sign the warrant. You will come anytime between tomorrow and Friday at close of business, 5 o'clock. Because you have to sign the electronic warrant in order for it to go into effect. So just make sure you come to criminal division. It's going to be the location at I-285 and Memorial with the helicopter on top of it across the street from the jail in DeKalb County. Just come there, go to the criminal division, sign it. And then once you sign it, I'll be able to sign it. I cannot do anything with the warrant until you sign first. So just make sure that you sign in that time frame so that I can know to sign and go ahead and get that issued. Okay. And we're going to email you some additional information about what to do about today's hearing. And just for whatever I was not able to clarify, you'll get an email with all of that. And if you still have questions after getting that email, the clerk's office is always open from 8:30 until midnight every day.
Real quick, Your Honor, it's going to be a little difficult. I am blind. I am a senior citizen. I do live by myself, so it's going to be difficult for me to get someone from here to Friday. I have to make sure someone can pick me up.
So don't rush then if it's going to be a difficulty for you. I'll just make sure that they let me know once you sign, but just understand sometimes things get lost in translation, for lack of a better word in the system whenever things are delayed by a lot of time. But take your time, get here whenever you can. And as soon as you do that, just let the clerk that helps you, let them know that Judge Neal asked them to let her know as soon as you sign that warrant. Okay.
Yes, Your Honor. And one last question, Your Honor. I did come down to the Camp Street and sign the warrant physically about 3 weeks ago, which moved this forward direction.
I don't know. You would have had to do an electronic signature so that they give you an electronic signature pad.
Yes, I did. Right there at the clerk's office, down at Magistrate, right across from Camp Circle. So I just actually, I signed electronically right at the window.
Yes,
that's correct, Judge. So
so I already have his signature in there.
Yes. Yep.
Okay. So he doesn't need to do anything else additional then.
No, you don't.
Okay, so Mr. Ford, you are correct. You have done everything that you need to do for this particular case. So we will go ahead and issue a warrant, and the solicitor's office will be in touch with you once they're able to track her down.
One more thing, Your Honor, I appreciate everything. Can they give me a courtesy call as well? Because I have an email address, but I don't use it. I haven't been on email in 5 years. I lost my vision in 2018.
You're talking about the solicitor's office?
If someone can call me, like you said, if they're going to email me something, if they can do me a courtesy follow-up phone call, because I don't receive emails, even though I have an email address. I haven't looked at an email in 5 years. I have no vision at all.
Okay, so what will occur is we don't need to email you anything else at this point. What happens, and Madam Clerk, do you have the ability, because I'm going to take a small break anyway, can you read over everything to Mr. Ford while I take that small break, and that would have been in that email that y'all would have sent him, just so he has all of that information and knows what's going on?
Okay, let me find it. No problem.
Okay, so Mr. Ford, I'm going to allow my clerk to just read that to you to facilitate everything. And I cannot tell you what the solicitor's office will do because I don't have any control over how they communicate. But typically what occurs is they will send you some type of notice in the mail once they have decided that they're ready to move forward. And if you make sure that we have your telephone numbers and everything, we will put that on the file that we send over to them, or the packet of information. And if the police officer had your telephone number on the police report, they will get a copy of that as well. But you may just have to call the solicitor's office to keep checking on it because I can't tell them what to do or encourage them to do anything that they do not wish to do, unfortunately.
I totally understand. Thank you. I appreciate it.
You're so welcome. So I'm going to go, you stay on. My clerk's going to read that letter to you so you have all the information that would have been sent via email. And I'm going to go research the next case so that I'm ready for the next case.
Am I dismissed after that, Your Honor?
Yes, of course, of course. Thank you for appearing and have a wonderful rest of the day. Okay, thank you so much. And so I understand that this person, you also dealt with her and she rented your vehicle from you on occasion, or used your vehicle for rental purposes. Is that correct?
Yes, ma'am.
Okay, and then I also understand that she sent you text messages where she said to watch your back and she was coming to beat you up. And then she sent another text message saying that she was coming to beat you up.
At my job, yes, repeatedly, that she knows where I work and I have to go to work.
Okay. All right. So what I will do in your case is I will do the same thing. I will go ahead and issue a warrant as far as it relates to her. What you will need to do is follow the instructions that the clerk will give. They'll send you an email later tonight or early tomorrow, just giving you instructions on what to do. But you will need to come to the courthouse, sign the warrant. Where, again, what I told the previous person, I-285 Memorial, the jail, across the street from the jail, the one with the helicopter on top at I-285 and Memorial. Just come sign it electronically before Friday if possible, and then I can sign once you have signed. Okay, so that will be everything that's required.
I did come in to sign.
Yeah, I'm sorry to interrupt.
Did she come in and sign as well?
They already signed, pre-signed the warrants already, yes.
Oh, everybody did. Oh, that's amazing.
Everybody did, yeah.
Okay, so great. So you don't need to do anything else. The solicitor's office will contact you once she's been arrested and once they start pursuing the case.
Okay, no problem.
Okay, thank you and have a good night.
You too. Thank you.
Okay. We will go ahead and come back into session. We'll go ahead and do the case of Sharman Douglas versus Latrina Richardson. Let me ask Ms. Douglas. Ms. Douglas, do you have all of your witnesses and all of your evidence ready today?
Yes, I do. I don't have any witnesses with me because they are on the camera.
Okay, so you do have access to all of your witnesses, or they have access to the Zoom, and you are ready to go forward, and you've sent us all of your paperwork.
I don't have no witnesses with me. They are on the camera.
Yes, I just said they're on Zoom.
No. They on the videos.
Okay. Do you wish to have your witnesses testify?
No, I mean, no, I don't.
Okay. And Mrs. Richardson, are you able to unmute yourself and start your camera? Ms. Richardson, are you ready to go forward with court today?
Yes, I am. I've actually
Okay.
already submitted.
No. If anyone else literally speaks out of turn or starts talking whenever I have literally said I ask very specific questions, I want very specific answers, I'm going to throw out your testimony and not hear from you. So do not speak until I ask a specific question. And again, these are yes or no questions. The next question I'm going to ask is, you said that you are ready. Is that a yes, that you are ready for trial? Okay.
Yes.
The second question will be, do you have any witnesses that need to testify?
No.
Okay. Do you have any evidence that you need us to see, to hear, or to read?
Yes.
Have you sent that evidence to the court already?
Yes.
Okay. So if everyone is ready to go forward and no one has any witnesses present, Mrs. Douglas, raise your right hand. Do you swear and affirm your testimony is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
State your name for the record.
Sharman Douglas.
Okay. You can go ahead and begin with your testimony about what you believe occurred. And I don't want to hear about a lot of background. Just to be very, very clear, I'll go ahead and read to you the reason that we're actually here today. This is going to be for the simple assault. It is alleged. Let me see exactly what is alleged. One moment. Okay, this is alleging that on 11/6, the hearing is going to proceed for simple assault. This simple assault occurred on August 26th of this year at 2:18 p.m. It is alleged that the defendant who is present hit you with a tree trunk that had fallen, twice attempted to hit you with a tree trunk that had fallen and threw the rest of the tree limbs on the property. And I'm not sure what that means, but that's what's alleged. So an incident regarding a tree or tree limbs on the property and being struck or attempted to strike you on August 26th at 2:18 p.m. That is what we're here for today. So you can just give me information about what you saw, heard, or witnessed on that day at that time concerning this defendant. So with that in mind, you can go ahead and begin with your presentation.
Okay, on August 26th, 2023, Latrina Richardson and her boyfriend cut the tree down. That's a shared tree between herself and mine, which is on both of our property line. However, the tree fell in front of Latrina Richardson's house, in front of her window. The branch fell in front of her window, which she had her boyfriend cut the tree down 3 weeks later. They in turn threw the rest of the debris, what they didn't want to take, on my side of my property. So when I came outside hours later, I'm looking and I noticed it's a bunch of tree trunks up under on my side of my property. So I'm like, I know that they didn't do that. So I pushed it back on. I pushed the stuff back on her side. I guess around 3-4 hours later, I'm sitting in my garage. Latrina and her daughter pulls up. She walks over to my property and tells me I got a lot of fucking nerves to be throwing that shit back on her side. We argue and counted in an argument. Her daughter kept trying to tell her to go in the house, cut it out. We arguing. She's saying she putting the shit back on my side, and I'm telling her she's not. So we constantly still arguing. Her daughter's still in her face, telling her mom, cut it out, cut it out. She tossing her daughter, throwing threats at me.
So what we're not going to do is make sound effects. If you can't control yourself, put yourself on mute, but we're not going to have sound effects or interruptions, laughter, snide remarks, smirks. It's court. We are in a court session. And again, I'm probably not in the mood at this point with all the interruptions that we've had tonight to be calm. One of the things that I can do whenever someone is in contempt of court is a deputy can come to your house. They can go ahead and take you into custody right this moment if that's what I decide is going to happen because you're being disruptive of the court process. Let's make sure that we're respectful so I don't have to resort to those means as I do not wish to do that. But we are going to act with decorum. Again, no comments, no smirks, no laughter. And if you can't control that, you probably should have yourself muted to make sure that that does not come across. Mrs. Douglas, you can continue with your testimony.
Okay, so as we're down at the bottom of the tree where we're at, and she's throwing the stuff back on my side, I'm picking it up and I'm throwing it towards the ground, back to her side. But she's taking the tree branch and she tossing it where it almost hit me in my face. So I did turn around and say, if that tree hit me, we're going to be fighting. I would be beating your behind. After that happened, the neighbors came across the street and they're trying to hold, as a matter of fact, I'm sorry, let me go back by the tree again. She claimed that I hit her daughter, in which I would never touch her daughter. And I asked her daughter, did I hit her? You were here in the tape. I asked her twice. But she kept trying to override me asking her, and her daughter said no. So I and him went up to my door to bang on my door to tell my son to camcord her. She's threatening, calling my job. I'm retired, disability. She's going to take pictures of us out here arguing and send it to my job. She also swung a punch at me while my neighbors was there. All of this is on camera. I, in turn, called the police because I was told that this should be on paper according to how she's acting and carrying on. Latrina swung a punch right by my face, and my neighbor happened to catch her fist and throw it back at her. So all of this is on the camera. I called the police. They arrived 11 something at night. I informed them that Latrina swung a branch at me, that she admitted to the officer that she threw it. She's tired. She's tired of stuff falling on her property, and she has to pay to pick it up. I've been living here. It'll be 6 years December. I have been nothing but a nice neighbor to
No, I don't
Latrina.
want to hear about anything other than that date. So
Okay.
anything that happened on that date is all I'm concerned with.
Okay. I reported to the officer, and in turn, the officer made the report as in Trina's favor. So video, I have 3 different videos from 3 different directions. And she did say that I came on her property when she was all over my property. I went on her property one time when she tried to swing at me because I almost fell into the tree trying to catch my balance. So I tried my best not to fight this woman, being nice
Well,
to
I
her.
don't want to know what you've done. I just want to know what happened. So
Okay.
did you see her swing the branch at you, or did your neighbor witness that? Did you witness her swinging at you?
And in the video, you'll hear me say, if that would have hit me, because that's how close she swung to hit me, it almost hit my face. The branch nearly hit my face. And she also swung a punch at me, which you'll see in the video as well.
Did you see her punch towards you?
Yes.
Okay,
She was
so you
aiming for
actually
my face.
witnessed it when it was occurring, not on the video, but did you actually see in real time?
Yes, I did.
Okay.
Yes, I did.
Okay. And you said that you've submitted video that you would like the court to see.
Yes.
Okay, Madam Clerk, do we have that video?
We do, Judge.
Okay. Mrs. Richardson, have you seen the video previous to today? Yes or no? What was that?
Yes.
Okay, so Madam Clerk, go ahead and play the video then.
It's petitioner 10.
Oh, this is 9. Okay, wait.
You could play 9 also, but I would rather her see petitioner 10 because that shows when she swung
She
on
doesn't
me.
need to know what it shows. So just
Okay,
you can
no
just
problem.
let
I'm
us know
sorry.
which one to publish. So we'll do 10 first, Madam Clerk, and then
Yes,
it's all the
Judge.
videos. So let's just do all the videos in whatever order you get to them.
Okay, I found it. Okay.
Thank you. Okay, Madam Clerk, you can go ahead. I'm ready now. How long is this video clip?
15 minutes.
Okay. Do I need to see the entire 15 minutes of this, or is there a specific place?
I want you to see she came on my property. This is me coming out. You can go up to like 4:20.
Okay, we can just stay actually if it shows her. Okay. So, Madam Clerk, let's just watch it in its entirety just in case I don't miss anything that makes sense. So just keep it scrolling.
Okay.
Who has on all black?
That's Trina, and this is me in the green top in front of my house. And this is Trina in front of me, standing there. That's my neighbors coming up.
No. I don't need commentary unless I ask.
Okay, sorry.
Madam Clerk, rewind by about a minute. Madam Clerk, will be able to rewind by about a minute and a half, 2 minutes.
Yeah, let me go back.
You can just leave it where, oh, sorry, I thought it was moving again. A little bit more, yeah.
You want me to go back?
Yes, a little bit more.
Okay. Yeah.
About the well, maybe 350 mark.
Okay. Right there. Let me see. 5 minutes.
Okay, let's go ahead and play that one. Are there any other videos?
No, Judge. The other is just photos.
Ms. Douglas, is there any other testimony that you would like to provide or any other video evidence you'd like to provide? You're muted.
I'm not my cousin is judge, but my name is Marionette Suggs and I'm a witness in this case.
Okay, so I had asked earlier if there are any witnesses. At this point, I'm not going to hear from any witnesses if they were present for the other testimony. So again, just like everybody else, please don't interject. And again, I cannot hear from you as no one indicated they had witnesses. And so I don't hear testimony if people are present for the main testimony from witnesses at this point.
Okay, I do understand.
So no further commentation from anyone that's not a party. Please do not interrupt. Mrs. Douglas, do you have anything else that you would like to present other than the testimony that you've provided?
Just, this right, the two videos was enough for me to deal with. So, I did send in a video of her talking to the officer and telling her that, yeah, she threw the tree branch, and if my dumb ass was, in the way, then I deserved to get hit, because if she wanted to hit me, she would have hit me. I mean, she just was irate. So this videos is enough for me, Judge.
Okay. All right, so Mrs. Richardson, I'm not going to find that there's probable cause based on this. I think both parties behaved extremely badly. However, both were yelling insults and attacks and things that could be considered fighting words. If I issued one warrant, I'd probably issue two warrants instead of just one warrant. So I'm assuming both of you would not like to go to jail, so I'm going to issue no warrants in this case. Mrs. Richardson, you have been put on notice that Ms. Douglas does not want you on her property. You are not to go on her property for any reason, because she's told you on a very public forum that she does not wish for you to be on her property. If you are on her property and she calls the police, they likely will arrest you. So do not go on her property. Again, I'm assuming that she doesn't want to speak to you. Had the two of you been willing to speak to one another, perhaps y'all would have agreed to do a mutual stay away or not talk to each other. I don't issue orders like that at this point, especially if I'm not finding that there is probable cause, but it would probably be wise for you not to speak to Mrs. Douglas either, again, unless you'd like to have the police invited back into your affairs. That is going to take care of this hearing for today. Both of you are free to go. If either of you wish there to be criminal charges that would pursue, you can call the solicitor's office, or you can contact the officer who did the initial investigation and see if they are willing to submit warrants on your behalf. But based again on what I've heard, I would not issue warrants only for the defendant if I were to issue them. And I probably would not even issue warrants for the defendant based on what I heard. So again, if you disagree, your remedy is not to talk to me from this point. Your remedy is to talk to the solicitor's office or talk to the officer who did the original arrest to see if they would get warrants on your behalf. Both of you are free to go. And Ms. Richardson, I just want to make sure I get an oral confirmation. You do understand that you are not to go on her property.
Yes.
And you will not speak with her, please.
Yes, I understand.
Okay. All right. So all parties in the Douglas versus Richardson matter are excused. Thank you for appearing. Have a good rest of the day. Mrs. Williams, just to make sure again, did you say that you had a witness? Yes or no?
No, ma'am.
Okay. Are you certain that you do not have any witnesses that you wish to call?
Positive.
Have you submitted all of the evidence, video, and otherwise that you need me to see?
No. No.
So you have not. Okay. At this point, if you have not sent it, there is an email address in the chat feature. You'll need to email it there. If we receive it before the hearing is over, I'll allow it to be seen. But if we don't receive it, then we'll have to go forward without it at this point.
I'm sorry, Judge. You said the email is where?
In the chat feature. You need to look in the chat feature and you should see the email address that you need to send it to. Ms. Colson, I'm going to have you unmute yourself briefly. How do I say Ms. Colson, are you ready to go forward with your hearing today?
I am.
Do you have do you have any witnesses that you think that you would need to prove your case?
I don't.
Have you already sent us all the evidence that you think we need to rely on to make a decision in your case?
I have.
Okay, so Mrs. Williams, I'm going to go ahead and I'll find the warrants and read the warrants while I'm doing that. Again, there's a chat feature. You'll have to figure that out. I can't necessarily explain it to you, but you'll need to find that feature, and you'll need to send an email to the email address in that feature in order for us to consider the evidence. But I am going to go ahead and go to the hearing as we are at that point in the day. So again, for both parties, this is going to be a warrant application hearing. Someone has indicated, and make sure that if you're talking or someone else is talking, that you mute yourself, because I don't need to be hearing what's going on in the background with either of the parties on today. So please make sure you mute yourselves if you have background discussions or talking going on. This is going to be a warrant application hearing. It is to determine if a warrant should issue against one or both parties in this issue or this matter. I'm going to read the specific warrants, and the only thing that we should be discussing this afternoon is going to be anything that is related to those specific items and that specific incident date and time. Based on what I have before me, this is going to be the case again of Williams versus Colson, according to the warrant application. It is alleged that there was obscene, lewd, or indecent telephone communications. These occurred on August 29th at 12 a.m. It is alleged that you made harassing, threatening telephone calls to the victim, and that is the extent of what is alleged in the warrant. So again, I need to just focus on any harassing or threatening communications on August 29th at around anytime on August 29th. So that being stated, Mrs. Williams, at this point, you can go ahead and let me know what happened on August 29th.
I'm also trying to send the recording that I recorded from that night. It's on the baby's tablet. I'm trying to send it to my phone so I can send it to the email because I can't send it from this tablet.
Okay. And you did not send it previously?
I sent it to the CS, I think it was the TPO place instead of the magistrate court email.
Okay. It is a audio recording?
Yes.
Okay. So I'll allow you just to go ahead and play it and see if it plays at this point. You can see if you can press play on it.
Okay.
What happened? I'm not even at home on me. I'm up here with my grandma because she at the hospital. We at Savannah.
Okay, Ms. Williams, can you pause the recording for a second?
Yes, ma'am.
I can only hear one voice. Are there two voices speaking?
No, that's only her. That's only her voice calling me. That's her.
Okay. So there's only one. No. But there's only one voice I should be hearing then. There's not two voices I should be hearing.
No, it was two because I tried to get her to talk so I can record because it wouldn't record at first. So that's when I said I only said what happened. The rest is her.
Hold on 1 second. Just listen to the very specific question. Y'all should know the drill at this point.
Yes, ma'am.
The only thing we could hear for the last 20 seconds or so of what was played was one voice. I'm only asking in that brief clip that we were able to hear, should we have been able to hear more than one person's voice for what we were able to hear of that clip?
Yes.
Okay, so we could not hear the second voice. Do you have some way to make it louder so that we can hear that there's more than one person talking?
No, for that's only one person talking right there.
Okay, so I'll ask again. The clip that you just played for us, were there two people's voices on that clip that you just played, or was there just one?
Yes, ma'am. Yes.
Okay, so we cannot hear more than one voice. So if you would like for us to hear more than one voice, you'll need to either play it louder, if you can increase the volume to your maximum volume on whatever device you're playing it on, and rewind it and play it from the beginning again.
Yes, ma'am.
Hello? What happened? I'm not even at home on me. I'm up here with my grandma because she at the hospital. We at Savannah.
Okay, you can pause it again. We still can't hear more than one person's voice. If you're able to send that recording to us, you can try to send it to us. We'll wait a few moments. If you're not able to, we'll have to reset it to see if we can get a better quality sound device. Ms. Colson, if we are unable to receive the video and we're unable to hear it, let me ask this of you. When would you be available to come back on December 4th for a hearing if we're unable to get the video quality today?
I'm not sure because with my work schedule and I'm also in college and I just had a baby and I have an autistic daughter that I'm helping my aunt with. Well, my aunt is helping me with. It's just a lot right now. And I don't even know why I'm here because I never even called.
Well, I didn't ask all of that, but so December 4th, you don't have a specific conflict with December 4th. You just have a lot going on is what you're indicating.
Yeah, just with my personal life. Yes, ma'am.
So Ms. Williams, were you able to get that sent?
Yes, ma'am. I sent it in.
Okay, hold just one moment. We'll see if we've received it. You can go back on mute until we're able to verify that. Okay. Ms. Williams, the clerk is indicating that both emails, she's received 2 emails total at this point. How many emails did you send?
I sent, let me see, let me go back. I think it was 3.
Madam Clerk, were you ever able to receive the video?
Yes, Judge, is on the screen.
Go ahead and play it and see if we can hear the sound.
Okay.
I can-
What happened? I'm not even at home.
Because I can't hear nothing.
Hello? What happened? I'm not even at home, Monique. I'm up here with my grandma because she at the hospital. We in Savannah. I don't know what to do. I don't know what to talk to. I really don't. His whole family was in the group chat talking about that and shit. They don't fuck with me.
I can't hear the sound.
I'm mentally unstable.
Okay, is there another recording or is this the only recording?
Her phone ended up going out, so that was all I could get. And then the call log and the messages.
Okay, Madam Clerk, are you able to show whatever messages, the text
Yes,
message?
Judge.
Okay, they have a messages on or
And that's one she sent. And then this is the other one she sent. And that's it, Judge.
that's all? There are no more text messages?
No.
Okay, Ms. Williams, are those the only text messages that you have?
No, it's actually a lot. It's just by the time I actually send it in, it's gonna have to get rescheduled. But I felt like I sent those 3 because it's a standing protective order in place. That's why I don't know. I just sent what I could right then. Well, right now. For violation of the protective order.
Okay, so we're not here for a violation of protective order. If you're alleging that she communicated with you in violation of a protective order that protected you from communicating with her, then you would need to submit that information. I'm
sorry, Judge. I did, the first judge that I spoke with, I did inform him that this was a violation of protective order, and he did state that he was gonna write it down or put it in as a violation. I'm not sure what he put it in as, but when I did speak to him a few weeks ago, he did inform me that that's what he was putting it down as.
Madam Clerk, do we have any other charge other than the harassing phone calls as far as it relates to this defendant?
I can double check.
Can I say something, Judge? 1 second.
This is, there we go. Oh, it was approved. Mm, No, Judge, I don't see, all I see here. Okay, hearing granted using telephone communication for obscene, threatening, or harassing purposes.
Okay, so I'm sorry, the device is still acting up, so I'm gonna have to use the other device still. You said, was it only the indecent telephone communications, or was there another charge that the judge who heard the warrant application wanted to issue?
So the judge who granted it has using telephone communication for obscene, threatening, or harassing purposes.
That's all.
Yep.
Okay. To do this, add not the harassing, violation of a family violence order, and add that charge. And what is the date that you're indicating, Mrs. Colson, that, or Ms. Williams, I apologize, that when does the protective order end?
It ends August 31st of 2020, August 1st, I think, of 2024.
Okay. What you'll need to do is also send us a copy of that protective order and all of your evidence that you'll need for the hearing, but I do need a copy of that protective order, and then you'll need something that shows that the text communications were on a date. So just the fact that you received the text, unless I can see the date and the time that it's received, is not going to be sufficient. So you'll need to send anything that shows the day and the time of the communication. And again, you'll also need to send the complete protective order granting you protection from her until 2024. I will go ahead and reschedule this since it's not complete information and not complete charges. I will reset this. Ms. Colson, let me ask you, I'm going to have to reset it either for December 4th, December 11th, or if I don't set it for one of those dates, I will need to set it for my first hearing in January, which is going to be January the 8th. Do you have a preference out of December 4th, December 11th, or January 8th? All of them are going to be Mondays at 6 p.m.
December 8th. Is it possible that I could defend myself or say anything on my own behalf?
Not right now, but it's going to be January 8th, December 4th, or December 11th. So you
January
said
8th.
Okay, you want the January date. So you will need to appear on January 8th. It will be in the same format, which is going to be a virtual format. If you have any witnesses, either one of you, that you would like for the court to consider, you will need to give those witnesses the Zoom information that we provide to you so that they can log in as well. When I go through the calendar, as you have both already been through the way that I handle the calendars, you're aware that at the very beginning of the calendar, I will ask if you have any witnesses. So if you would like your witnesses to participate, you'll have to let me know at the very beginning of the calendar so I can make appropriate announcements. If you have any evidence you would like me to consider, pictures, screenshots, anything at all, you'll need to email that to the clerk's office. We put that email address in the chat feature. If you don't have it, look at whatever letter we emailed you with the notice for this hearing, and that will have the clerk's information on it. If you can't email it and you cannot figure out how to email it, you'll need to physically bring a copy down to the courthouse so that we can get it in our systems. I would not be inclined to reset this a second time on January 8th because I'm giving each side sufficient time to get that together. If either of you feel as if you need the services of an attorney, you'll need to let that attorney know that the hearing is scheduled and will not be rescheduled, and it is scheduled for January the 8th at 6 p.m. Again, that's going to be a Monday. We always have this type of court on Mondays, and it's always at 6 p.m. And again, just make sure that they have the Zoom information that we send you. If for some reason this gets to be the beginning of January and you still haven't received the notice letting you know of the time and the Zoom information for the January 8th meeting, give us a call because I'm specially setting you down on that calendar. So unless something happens that's outside of my control, like another phase of COVID or something of that nature, something that drastic, it's going to be January 8th. So just call the clerk's office and say, hey, Judge Neal set my hearing for January 8th. I haven't received notice. It's January 2nd. I need to get the Zoom information so I can call in. So we should definitely have it to you by that first week of January. If you don't get it, we still have you scheduled for court. I will see you personally on the 8th at at 6 p.m. Make sure you have all of your evidence, all of your witnesses, and both of you will have a chance to testify then. I'm not going to hear any additional testimony tonight, since it's come to my attention that we don't have all of the charges and all of the information present. If you have any questions, you can call the clerk's office and they'll be able to further advise you about anything else. But again, make sure you have your witnesses, give them the Zoom, call us if you don't get the Zoom information by the 1st of January. And then also, if you can't send it to us electronically and get confirmation that we've received it, then you need to bring it physically to our offices. And if you hire attorneys, make sure they know January 8th. Witnesses January 8th. If you need to subpoena somebody to make them come to court and force them to come to court, you need to get that subpoena today or this month if possible. Okay, so Ms. Colson, thank you for appearing. Have a good rest of the day. Ms. Williams, thank you for appearing. Have a good rest of the day. I'll see you January 8th at 6 p.m.
Thank
Ma'am.
You hold on one second. So Ms. Williams, I don't really answer extra questions. So any other questions you have, I'm gonna have you talk to the clerk's office after we get out of the court session, okay?
Okay.
All right, so that will